We have just seen a major legal challenge to the Leasehold and Freehold Reform Act brought by some of the biggest freeholders in the country, and they're taking on the government. I'm going to talk today about what the outcomes were, the sort of main arguments that both sides were making, and most importantly, what this means for leaseholders. Hi, I'm Josh from Short Lease Property Sales. We are the estate agency specialising in short lease flats, and obviously that includes everything to do with the Leasehold and Freehold Reform Act. And to save my jaw in this video, I'm going to shorten that to LAFRA. Much easier for me to say, much easier for you to listen to. Right, quick reminder about LAFRA. How do we get here? What is it? It was introduced at the end of the Conservative government. Main aims were to make it easier for leaseholders to own and extend their lease and make it cheaper as well. It's all passed through Parliament, but it's not all law yet. You'll see some bits have been introduced already, others, such as what was being challenged by the freeholders, not yet being enacted. And it just happens that the bits that haven't been enacted yet are the ones which bring the biggest potential benefits for leaseholders. The main argument from the freeholders in terms of why LAFRA shouldn't be going through as it's initially been entered is that they're saying it's wiped millions, possibly even billions, off of their asset value. They own thousands of properties, of which a significant percentage are short leases, and therefore taking away lease extension funds is going to be damaging to their finances in the future. That's why they brought this court challenge. And their main argument is that this removal of their value, their taking of their assets without fair compensation, is infringing on their human rights. That's a pretty serious claim, of course. And so they've tried to back it up by saying they're not receiving fair compensation because costs are being removed in three main ways. The first is marriage value. That's the amount that you pay as a leaseholder to a freeholder when you want to extend your lease and your lease is under 80 years remaining. It's a 50% payment of the increase in value that getting the new lease adds to the property. So that's a huge chunk of any lease extension premium. Probably the most significant factor here for the freeholders as well. The second is a ground rent cap. So that's taking into account what ground rent can be used in the lease extension calculation. And the third are their legal costs. Currently, if you want to extend your lease, you have to not only pay your own legal costs, but you also have to pay legal costs and valuation fees for the freeholder. Some might say that's unfair. It's how the system's been running so far. And therefore, the freeholders are saying, you're removing these three benefits from us with no good reason and without taking a balanced and fair view. Therefore, this is impeding on our human rights. Now, it's not definitive. It's a case that's being argued, but there's obviously a decision that needs to be made on whether it is or not. The government's argument in defense of LAFRA fundamentally revolves around, well, there's a few different areas, but the main thing that they drew on is something called the Bank-Mellet test. It's an important legal concept. It's from an old case, and it's about the framework which the UK courts use to figure out if the government's actions, including new laws, where they interfere with human rights, if they're justified. It comes from that Supreme Court case, and it asks four questions. First, is the objective important enough? So what the government's introducing, is it serious enough for them to justify limiting the freeholders' human rights? Two, is there a rational connection? So does the action that they've taken, the new law they've introduced, help achieve the goal? The goal in this case being making it easier and cheaper for leaseholders to own their properties and to extend their leases. The third is considering alternatives. Are there less intrusive alternatives that the government could have done which wouldn't have impeded on the freeholders' rights as much as this they're arguing has? And the fourth, is there a fair balance? Does the severity of the measures and the redress of value from freeholders to leaseholders, does that bring more net benefit? Is it fairly balanced between the freeholders and the leaseholders? And do the rights of the freeholder that are being taken away be outweighed by the benefits that the leaseholder is gaining? So the government is essentially arguing that LAFRA's aims, which I've mentioned, simplifying the system, making it easier and cheaper for leaseholders, reducing their costs, are important. The methods that they've taken to address that balance are logical. And despite the financial impact on freeholders, the overall balance of these measures would be fair and it would be proportionate. So in their view, it meets those 4 requirements. There were other arguments along the way, and there's a whole heap more evidence from both sides that hasn't been considered verbally. There's lots of written documents for the judicial review to go through. And the outcome from this week is that the 2 judges who are sitting on the case want more time to review it. They've allowed the review to continue. They are now going to go away and review more. And while the outcome remains very uncertain, both cases are argued. Some could say that the government won, some could say that the freeholder put forward a good argument. We don't know ultimately what decision is going to come out of it. The one thing we do know for certain is there will be a definite delay. There's a delay right now because the laws aren't going to come into full force while this is still being reviewed. And even if this is reviewed, the freeholders and probably the government as well, if it doesn't fall on their side, are probably quite likely to appeal. So what does this mean for the leaseholder? Definite delays. Potential appeals means there's going to be at least months worth of delays, possibly even years. And then there's the uncertainty. What is the outcome going to be? Will lease extensions actually be cheaper in the future, or will they end up at a similar point to where they are now? Ultimately, that's not helpful necessarily if you're trying to make a decision on whether to sell or whether to extend your lease right now, apart from thinking through the timeline. So the main implications, if you're thinking about selling, do you want to sell within the next few years? Do you want to sell within the next few months? Certainly if it's months, then the view might be that you would want to take action now. It's going to be your own decision. It's going to depend on your own circumstances and your own thoughts on this. But a lot of people that I've spoken to were waiting for leases to become cheaper before they extended, before they then sold. Some of those are going to bring those decisions forward. They might say, well, look, I'm uncertain even now how long this is going to go on for. I thought it might have been a couple of years. We've waited a long time already. It's time to get on and get sold. Others who say, well, I don't need to sell for 5 years or so, might still be willing to take that risk that their lease will be cheaper in 5 years' time. So they might settle in for that longer wait. Ultimately, which is right or wrong, there's no definite answer. It depends on each individual's circumstances. It depends a bit on their interpretation of where things are going with this court case. If you want to discuss your individual situation, get our views on it, different opinions on ways you could move forward, then absolutely feel free to be in touch. I'll put the contact details in the link down below. You can also get in touch through the website shortleasepropertysales.co.uk, and we hope to speak to you soon.